Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me right here on this station every Sunday from 8 to 9 a.m. where I bring you, the landowner, the valuable information that you need regarding natural gas development here in Pennsylvania. In case you've somehow forgotten, remember this: I have not, do not, and will not represent oil and gas companies. I represent Pennsylvania landowners and Pennsylvania oil and gas right owners. I have and continue to represent landowners as such items as gas lease negotiations, reviews, consultations, pipeline right-of-way agreements. I have negotiated, consulted on, and worked on pipeline agreements with over 60 separate companies. 60 separate companies here in Pennsylvania. Also, royalty deduction issues, surface use agreements, compressor site agreements, meter site agreements, estate planning, anything. Doing more of been engaging in more and more real estate transactions and issues involving gas or in areas where there's oil and gas production or anticipated oil and gas production. Represent landowners who are considering selling their oil and gas rights, where I first explain why you may not want to do that, but represent landowners in oil and gas rights transactions, you name it, anything whatsoever related to oil and gas development in Pennsylvania. And if you need representation, you can always contact the office here at 570-307-0702. That's 570-307-0702. What you also need to do, if you haven't done it yet, and if you do, or if you have done it, you need to do it again. And I mean it. Go check out our websites. This isn't a plug to say, hey, hire me. Go check out the websites. Get some good quality information regarding natural gas development, the various types of agreements, things you need to be looking out for. Also, prior radio shows. I have been doing the show since 2010, so we have, I think, a couple years of prior radio shows, the last couple years available on the websites. And today's show will be up and available on Monday morning as well. Another neat thing we do on the websites, we index the radio shows by topic. So if you're interested, you're listening today and we're talking about something today, you say, well, I'd really like to hear a show maybe more about pipelines. Well, go to pagasleaseattorney.com or go to pipelineattorney.com. And you can go and listen to prior radio shows on pipeline issues. But also, as you may suspect, pipelineattorney.com has a lot of valuable information for you, the landowner. Another thing that I do is this monthly newsletter, completely free. We don't bother you. We send it out about once a month. It's informative. It's on a hot topic facing Pennsylvania landowners, whatever that may be, in a given month. And it's free. There's no obligation. We don't bother you or anything. And you can sign up for the newsletter online at pagasleaseattorney.com and pipelineattorney.com. Also, if you want, we'll just say real quick, you can follow me on Twitter. And I'm at Douglas Clark, at Doug Clark Law. So you can follow me on Twitter, Douglas Clark, at Doug Clark Law. And you can also check us out on Facebook. We have the All Things Marcellus Facebook page. So I really encourage you, I really do, go check out pagasleaseattorney.com, check out pipelineattorney.com, and use that information as a resource, as an educational resource. That's why it's there. Sign up for the newsletter, same thing, educational resource available. Education, we want to raise the education level of all Pennsylvania landowners and oil and gas right owners, because the more information that's out there for the landowner, and the more the landowners read and learn and use that information, the better it's going to be for each individual, but also for everybody. When everybody becomes educated, when everybody stops signing really bad agreements for themselves and for their property, that raises the offers across the board. You'll hear me say, take a pipeline agreement, pick a county. I was just at Tioga County for a seminar. Take that county. There are offers out there at $5, $7, and $16 a foot. My opinion, way too low. I routinely have clients sign easily over $30 a foot, but over $50 a foot, $60 a foot, in some cases over hundreds of dollars per foot. Some cases. Every case is unique. But I'll tell you this, I don't have clients signing at $5, $7, and generally $16 per foot. In my opinion, it's too low of a price in almost all situations, especially $5 and $7 a foot. No, thank you. I would never sign it. Not specific advice for anyone, but I'll tell you what, I would never sign it. Not for any of the property that we own would I sign a $5 or $7 per foot right-of-way agreement. Would not sign it. And if the company says we can put it in under the lease, I'd say go ahead and put it in. But I'll tell you what, company, if you do that, remember, you got to follow the lease terms, and it may be only, in most cases, the only gas you can run through that pipeline is my gas and gas that I'm sharing with other people. And by the way, if you're going to run other people's gas through my pipeline, and if you are allowed to do that, in almost all cases, when my lease ends, your right to have that pipeline in the ground on my property also ends. So you got to get that pipeline out of there. So think about 50 years, just an example, your gas lease ends and there's a pipeline on your property transporting gas from all across the region. Well, that company, if they lose their right to have the pipeline there because your gas lease has terminated, which will occur in almost, not every, but almost all cases, well, company, get that line out of there or you're going to have to pay quite a bit of compensation. What you will find is, in my experience, and look, I do this all the time, what you will find, company says, we can put it in, we're going to put it in, we can put it in. We'll put it in under the lease. If you don't sign, you're not going to get this much bigger compensation package. If you do sign, we're going to pay you more, even though we don't have to. Remember, look, companies aren't in the business of paying people more when they don't have to. So why do they want you to sign a separate pipeline agreement? Because they want to have and they want to purchase additional rights in the pipeline right-of-way agreement. What do I mean? Well, when you sign a pipeline right-of-way agreement, it is a separate legal contract than your gas lease. So when your gas lease terminates, the pipeline agreement stays. They're separate contracts. If your gas lease says you can run gas through pipelines only if it's my gas or from my unit. If it says that, most leases I see, most, not all, most, say that. So when you sign a separate pipeline agreement, that agreement is going to allow gas from anywhere, to go through pipelines and be transported through pipelines or a pipeline across your property. So as a general rule, leases will tend to end much sooner than pipeline right-of-way agreements. Leases will tend to end sooner than the pipeline right-of-way agreement. Do not think that, I had a gentleman ask this the other night to me when I was at this seminar and said, well, I have a gas lease that expires next year and the pipeline company has approached me to sign a pipeline right-of-way agreement. So if I sign this right-of-way agreement, then come next year when my lease expires, won't my pipeline right-of-way agreement expire then as well? The answer is a resounding absolutely not. Absolutely not. So that gentleman could have a situation where next year his lease expires. He's no longer leased, but that pipeline agreement stays in place. They then install a pipeline on the property, and the gentleman does not have a gas lease. So now he has a pipeline across his property, no gas lease, no royalties, and he better darn well like the compensation that he was given because that's all he got. Now, there could be a gas lease in the future, but the reality is he signed a separate document that runs separately, And do not get confused. Do not get confused. When you're signing a separate pipeline right-of-way agreement, you're signing a separate, powerful legal contract. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here on this station every Sunday from 8 to 9 a.m. You miss any of today's show or want to go back and check out hours upon hours of prior shows, you can go to pagasleaseattorney.com and pipelineattorney.com. Have the shows up, available, and archived on the websites. I'm going to transfer away from pipelines here in a second, but I just want to remind everybody, please, 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 if you're considering a pipeline agreement in today's market, let me just do this. Northeastern Pennsylvania, you may have quite a bit of leverage, and you may be able to obtain a much higher compensation package. You got to get assistance and understand your situation. Don't be promised, this applies to everybody, don't fall into the trap of, we want to get your royalties. Only way we can do that is pipelines. We need pipelines. Pipelines equals money. Here's a pen. Here's the paper. Sign. We'll get you money. Don't fall into that trap. Don't fall into that trap. Hundreds and hundreds of people have already. Don't fall into the trap. Now, North Central Pennsylvania. Companies out there extending leases, not drilling, offering 10-year leases. 10-year leases, which through shut-in provisions, through continuous operation provisions, and other provisions in the lease can actually extend even longer than 10 years. You sign a 10-year lease, you're not guaranteed to get royalties in 10 years. You're not guaranteed really anything. And in fact, they could start drilling. They could file for a permit under the lease at the last day of the last year, then go into a due diligence drilling program, which may take another year, then shut you in for 5 more years. Now we're at 16 years and you haven't seen a royalty. Now, is that going to happen every case? No. Could it happen? Absolutely, yes. Absolutely. So pipeline company, landman comes to your table, says, hey, we got to get your royalties, we want to get your money. Here you go, here you go, here you go. Well, why is the gas company giving me a 10-year lease? If you want to get me royalties, gas company, let's sign a 5-year lease. Let's do something different. Why am I going to rush for a pipeline right-of-way agreement when I got a 10-year lease offer? And let's ramp it up and ask even a better question. Why am I going to sign an absolutely terrible pipeline right-of-way agreement at this time for very, very little money, less than anyone else in the state is getting in any regular basis, and with very friendly company terms, not friendly landowner terms, friendly company terms? Why am I going to do this? Why? I don't know in most cases. Not specific advice for anybody. Always remember that. But I'll tell you what, you better be thinking about this unless you just don't care. I mean, if you don't care, you say, hey, I'll take $5 when I might be able to get 30. I'll take $7 when I might be able to get 20. If you want to just take less money, if you want to give the company more rights than what you have to, sign away. Just, sign away. Go out to the store, buy a bunch of pens, and sign everything they put in front of you, if that's what you want to do. That's not what my clients want to do. That's not what most people want to do. If you have a chance of signing an identical contract, and one is for $50,000 and one is for $100,000, which one do you want to sign? Which one? I mean, this is silliness. So we need to make sure that we're getting the most money, that we're getting the best terms, and that we understand whether today's the day, this is the year, or should we wait? Why am I doing this today? Why am I rushing when a company is posing to me a 10-year lease agreement? Again, not specific advice, but my heavens, we got to be thinking about these things. We got to be looking at these things. Western Pennsylvania, same type of thing. What are my rights under my lease? All of the same things apply. What am I being offered? Do I need to sign this? What is the development stage? Where are we at? Same questions here. And circling back to what I started on earlier, and I'm going to finish it here before the break, you're being offered $5, $7, $16, $15, $20, whatever the case may be. I don't care if you're offered $30. If everyone quit signing these bad agreements, what would happen? Everybody who is offered agreements would be offered better agreements. So if you want to sign a bad agreement, go ahead. But what we need to happen for people who want to do this intelligently, we got to get the people who are going to sign bad agreements, let them sign. Because then once the company's done signing everyone that'll sign a really bad agreement, they raise the price. They offer more money. They offer better terms. So 2 things. Don't be the low-hanging fruit. Don't be the signer. Be the intelligent landowner. Then you're going to do better. And if you're going to be someone who's going to sign, be the high-hanging fruit. Let the low-hanging fruit get picked. You're going to wait, and you're going to do the best you can, and you're going to sign for higher compensation, better terms, and you're going to do better and protect you, your family, future generations, and your property. You're listening to All Things Marcellus, having a good time today with Attorney Doug Clark. I'll be right back after this. Remember, an extremely important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm right here with you every Sunday, 8 to 9 a.m. on this station. Okay, let's jump into it. I'll tell you what, some days I feel very energetic, some days not so much. Coming into today's show, I got to say, I wasn't feeling as energetic as I'd like to be, but I'll tell you this, got going in the first segment, so I'm getting fired up, so let's keep it going here. Okay, here's what I want to talk about. I tell you, this week, I had a lease and a lease review, and a client was considering a lease with an addendum. And, you know, I create these lists during the week and say, hey, this would be a good topic. This would be a good topic. Well, I went through this addendum, and I think I got about 5 radio shows out of this one offer. It's amazing. I really think I may have 5 radio shows out of one single offer. Now, I'm not going to do that. We're not going to go that deep into this one single offer, but it just gives you an idea. I found so many fascinating things in this lease and the addendum offer and all these loopholes and issues with the offer that it was just amazing to me. So I said, well, all right, we'll mark some things down. And here's a couple things. I'm going to highlight on a couple of them, which are really, really fascinating to me. And I'm going to start with an indemnification provision. I'm going to read the whole provision, but I'm going to read what I find to be very interesting. When I say fascinating, it's not fascinating in a good way. It's fascinating in a bad way for landowners. So let's talk about this. Indemnification, hold harmless. This is the language. When you see that type of heading or you see that language, the idea there is a positive thing for you, the landowner, to protect you from liability. All right, great. But the word indemnification, the word hold harmless, doesn't by itself protect you from liability. These are very complicated provisions that are written with a lot of legalese, complicated language, twisted around, and you better understand it, and you better understand the level of coverage that you're getting. You may say, okay, great, I got indemnification. I got hold harmless. I listen to that guy in the radio, and I know that's a good thing to have. That's great. I don't need any. I don't have to go to a lawyer. And this, not to be commercial, but listen, these provisions are very complicated. Many times I have to read them over and over and over, break them down to make sure that I understand them. And I've read, thousands of these provisions. So it can be very complicated. Just because you have buzzwords, indemnification, hold harmless, other buzzwords that you'll see in leases, no deductions. Don't fall victim to buzzwords. You go online, there's studies of psychology. People remember a couple things. You can read an article, you remember a couple things. You hear me talk about indemnification, hold harmless. You remember, hey, I need that. You don't remember all the details of the language that you need. Also, same thing. You go to royalty issues. You say, okay, I'm out online. I listen to this guy on the radio, and I know that I want to avoid, mitigate, reduce the impact of deductions for post-production costs, items such as transportation, pipeline transportation fees, pipeline gathering fees, compression fees, other associated post-production, after production fees. You want to avoid them. Everybody does. You need to try to avoid them. So, what do you take from all that? Not all the complicated language talking about market enhancement, ready for seller use, realized revenue, affiliated, non-affiliated sales, third parties, arm's length transactions, all of those things. No, what you remember is no deductions. Deductions are bad. No deductions. So the companies, in a shocking turn of events, aren't stupid. I say all the time, and a shout out to Jimmy Sanderson, it's not their first rodeo. It's not their first rodeo. They know what they're doing. They're not oblivious to the internet message boards, websites, things like that. And I can tell you this. Hi, guys. I know they listen to the radio show. So hello, everyone. How are you guys out there for the gas company today? Hopefully you're doing well. But my point is, the companies know. The company lawyers know. The landmen know. They know what they're hearing out on the ground when they're going out and talking to people. Landowners are saying, I want no deductions. I want indemnification. I want no deductions. So what do? They go into little think tanks and they say, okay, guys, these landowners are all telling our landmen on the ground they want no deductions. Well, okay, what do? We don't want to give them no deductions, so why don't we do this? Why don't we use these buzzwords, no deductions, and it may give the impression that there are no deductions, but actually there would be the ability, and it will be, under proposed language, the ability to take deductions. I have looked at so many leases where the landowner has been told, hey, you're not going to have deductions under this lease. And I say, look, there's no way in the world that anyone can guarantee you that with this language. I can't guarantee you that. And sure as heck, the person telling you that you're not going to have deductions, see if they can guarantee you that. Ask them, get a guarantee from them in writing. See if they'll do a little separate thing. Say, hey, listen, if I get deductions taken from me, you agree that you'll be personally liable or responsible to pay me back these deductions because you verbally or orally advised me that with this language, I won't have deductions. And I will guarantee you, that person won't sign such a guarantee. And if they do, they're going to be banking on you're never going to come back after them, all right? Because the truth is, you can't guarantee that. You just can't guarantee it. And even if the certain company is not taking deductions, many other companies may be taking deductions. These leases are sold, flipped, transferred, assigned. We got cases, literally, I have hundreds of cases where under the same exact lease, one client has deductions taken from one company, is taking deductions, and the other company isn't. So companies realize no deductions. That's the big buzzword. That's what everyone's talking about. Then I start seeing addendums that have a heading that says royalties, no deductions. Royalties without deductions. And then I read it and I say, my heavens, I can point out 7 companies right now that are taking deductions under this exact language. So I don't know how you can say, just words, I guess you can say them, but I don't know how you can really say with meaning and confidence that there's not going to be deductions taken with this particular language. Because even though the company who may be signing a lease with you with that language would not take deductions, as of today, they could sell it, assign it in whole or in part. They could give another company 30% of the lease, and that company with 30% may have a policy where they take deductions under that language. Or instead of giving that company 30%, maybe the company that you sign with sells all of their interest to a company that will take deductions. So you have these buzzwords, no deductions, no deductions. Hey, that's great. And then you get a check, and then there's all these deductions taken. Well, don't fall victim to buzzwords. Understand what these buzzwords are, and you like to see buzzwords, but you gotta dig deeper. You have to dig deeper. You have to look at the language. Just because something says no deductions does not mean that you will not have deductions in the future. Maybe it does. We got to look and dig deeper, but I'll tell you, many, many, many times it does not. You need to be careful. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here every Sunday from 8 to 9 a.m. So I'm talking about buzzwords a little, and my point is be careful. Be careful. Buzzwords can be good, but they are buzzwords. And what does that mean? You have to dig in below. Read some of these royalty provisions. Read them. And I'll tell you, I read some literally 10 times, and I still am not sure I fully understand it. I can read the words, I can break down the sentences, but I don't know how they're going to apply this. And what we need to do then is try to change that language so it's understandable, to eliminate loopholes. And if you can't, then there's a discussion I have with my client landowner. Okay, here's what you have. Here's what we see. Here are the type of provisions that we see companies routinely taking deductions under. Here's what I see companies do with this particular provision. And when you talk about market enhancement clauses, you talk about what we call the ready for sale or use clauses, which are extremely, extremely common out there. I mean, literally thousands. There's probably 10,000 plus leases that have these clauses. Well, you need to understand that different companies treat these clauses differently. You need to understand what the company presenting you with this lease, how do they treat this clause? That's good. You want to know, and if they don't take deductions, that's good, but you need to know they can partner with another company, they can assign, sell, or transfer all or part of your lease to another company, and that company's policy may be taking deductions. You need to understand. Now, look, ultimately you may say, hey, and most people ultimately make a decision, you're going to either sign or not sign. Well, you may sign, but if you do, you understand the language you have, where the holes are, the risks that you're taking, and certainly how your company treats this language as of today. And why am I talking about deductions? Anyone getting royalties knows why I'm talking about deductions. But a quick example, I had a pretty decent-sized client, not by far not the biggest client, but a pretty decent-sized client. I don't want to overstate it, well less than 500 acres, well less. But they, the company who was paying them royalties didn't code their lease correctly. And that's what they call it when they enter it into their system as a gas company as to how they pay the landowner. And we'll make this very simple. You could code it when you enter it in to the system as this is a lease where we as a company take deductions. The lease authorizes us to take deductions for items like transportation, gathering, compression, and other post-production, after-production costs. So they enter it in as it's a lease that they're not allowed to take deductions. So in this case, it was a lease that the company, and I have to say also, clearly was allowed to take deductions. But they made a mistake. The human who entered it into the system made a mistake and entered it in as the company was not allowed to take deductions. So landowners are getting royalties, this landowner, getting royalties without deductions. I'm going to explain what happened here, which is going to be it's going to be a lesson in a lot of different ways, but certainly what are these potential impact of deductions? We'll dive into this in the next segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm right here every Sunday, 8 to 9 a.m. on this station, and I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always contact me directly, 570-307-0702. 570-307-0702. Okay, and also, again, check out pagasleaseattorney.com. Check out pipelineattorney.com. I can't believe how many people aren't doing that. Listen to the show, but don't check out the websites. Again, I don't care if you're looking for representation or not. Get information. Educate yourself. We may be in a lull here with these real low natural gas prices in a lot of places, in a lot of areas. Become informed and become educated. So when things pick up, you already have knowledge. You already understand. Then I'm going to put my pen down and not sign anything. I'm going to get even more information. I understand what the potential issues are, so I'm going to be careful. All right, let's circle back around here. So I was talking about buzzwords, deductions. An example, I had a client with several hundred acres. And I'm gonna I don't want to get too specific, so we'll use some hypotheticals, but I'll just tell you they're gonna be close to being pretty darn accurate. All right, client has a lease, and this lease is an older lease that clearly, I can't argue anything differently, clearly allows the gas company to take deductions for post-production costs like gathering, transportation, and compression. Clearly is allowed. The company, by mistake, and this happens way more than what you would think, by mistake, miscodes the lease. When they enter it into the system, they made a mistake and they entered it into their internal system as though, or in a category, that they were not, as a company, allowed to take deductions. They paid royalties for right around a year or so, and they didn't take deductions. This company also didn't have a 100% ownership of the lease, meaning that they were a partner with another company who was also paying royalties under the same lease. So they didn't even have the majority of the lease. I'm just making an easy example. Say one company owned 70% of the lease, and this company owned about 30% of the lease. And the company that owned 30% of the lease miscoded the lease when they entered it into the system, and they were not taking deductions. Now, the other company who owned 70% of the lease didn't make the same mistake. They were taking deductions when they were paying royalties. So the landowner is receiving their royalty checks. And this is one area, no matter how involved you are, how informed and educated you are or not, when you get royalty checks each month from two different companies, and the company that owns 70% of your lease is taking full deductions like they're allowed to under the lease, and the company taking 30% of the lease isn't taking deductions, you can see that in your checks, because you may see the company that owns 70% of your lease is paying you perhaps even less than the company that owns 30%, because the company that owns 30%, in our example, isn't taking deductions. The 70% company who owns the lease is taking deductions. You can pick that up pretty darn quickly. So let's make this hypothetical. But I've had this happen several times. Landowner calls, says, hey, I'm getting paid differently here. What's up? So we look at it and say, well, it's pretty clear. I can tell it looks like the company, we'll continue with this example, that owns 30% of your lease has made a mistake. They miscoded your lease and they entered it into their system as if they weren't allowed to take deductions. So they're paying you without deductions. So the landowner, of course, says, well, all right, well, what do? I like being paid without deductions. Well, of course, we all would like to get royalties without deductions. But if your lease allows the company to take deductions, well, what can happen here? You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. What can happen? Well, I'll tell you what can happen. As I tell my clients, here's what can happen. The company can figure it out. They can ultimately find out that, in fact, they miscoded the lease and have been paying you more royalties because they weren't taking deductions than they should have. So you, as a royalty owner, a landowner receiving royalties, have a couple choices. You can sit back and do nothing and hope it's not caught. Or you can say, hey, company, I think maybe you're taking or not taking deductions when you should be. Well, that doesn't seem like something you want to do, because the company's going to say, oh, geez, thanks, and they're going to start taking deductions. But there's a second part. What also is the company going to do? Well, if you tell them, company, you're not taking deductions, the other company who's paying me is taking deductions, I think that you should be taking deductions. Well, company says again, hey, thanks a lot. We miscoded the lease. We're going to recode it and now take deductions. And by the way, since we had been overpaying you for, let's say, the last year, we're going to recoup or get back the money that we've overpaid you. Meaning that you total up what were the total deductions in the last year that the company should have taken but didn't take, and they actually paid you that money. So the company will say, we've done our math, and we have overpaid you because we weren't taking deductions that we should have, and so now we're going to put your royalties in what's called suspense, meaning we're not going to pay them to you, and we're going to recoup the money that you owe us because we overpaid you. Very, very common. So again, if you alert the company, that's what they're going to do. That's what they're going to do. What if you don't alert the company? Well, had a client, again, let's go hypothetical, doesn't alert the company. Company, though, finds out. They do reviews. They find out, hey, somebody made a mistake and miscoded it. Well, this occurred for a decent amount of time. Also, depending upon how many acres you have. If you have 1 acre or if you have 100 acres, it's going to be quite a bit different. Well, in this case, all of a sudden, landowner doesn't receive royalties from the company that owned 30% of their lease, roughly. Again, hypothetical, but generally tied to a real situation. So company or landowner now who's not getting or finds out they're not going to be paid royalties, and they write the company, call the company, communicate with the company. Hey, what's going on? Why didn't I get a royalty check? Well, we figured out that we made a mistake. We were paying your royalties and not taking deductions. So we're now putting your royalties in suspense, and we're going to wait, and we're going to each month as royalties come in, we're going to deduct, I shouldn't use that, we're going to subtract what money we would pay you in this month or any given month from the amount of money that we've overpaid you. Now, in this particular case, hypothetical case, the landowner owed the company over $50,000, $50,000 plus dollars that the company paid them when they should have taken deductions. So what do I mean? Again, I'm sorry if it's repetitive, but I like to restate it to make sure everyone's following. So what we have then is, because the company wasn't taking deductions, they added up the amount of deductions they should have taken, let's say over the last year, and it's about how long it was. And they said, geez, we paid you $50,000 that we should not have paid you. So now what we're going to do is every month, say you were going to get royalties in the amount of $2,000 in a given month. Well, now instead of you owing us $50,000, we're going to subtract that $2,000 and you're going to owe us $48,000. Well, again, this is just an example, but I can tell you that when these things, obviously, the longer they go, the more this compounds. So in this hypothetical case, our landowner the company found out they were not paying properly after about a year, and those deductions in the course of a year exceeded $50,000. Now, again, this landowner in our hypothetical, had a decent amount of acreage. Not 1,000 or more acres, but it had a decent amount of acreage. So think about this. Landowner says, okay, well, I'm going to risk this. I'm going to let it ride and see if the company catches it. Well, what if the company doesn't catch it for 10 years and we had, $50,000 a year on average? Now you owe the company $500,000. What if they catch it in 10 years and you owe them $1 million? What if they catch it towards the end of the lease and there's not enough royalties left over from gas that's going to be produced to cover the amount that they've overpaid you? So here, let's use this example. If we say it's $1 million in deductions every 10 years, say the company catches it at 30 years, and now they say, hey, landowner, we paid you $3 million that we shouldn't have paid you. We want our money back. Yeah, we're gonna put your royalties in suspense, and we'll start recouping or subtracting whatever royalties you were due in a given month from the total amount of royalties that you owe us back. We've overpaid you. In our example now, it's $3 million. Well, say the royalties that are left in the wells from your property, in this case, are only worth, say, $500,000. Well, now you have a $2.5 million balance with the company. And the question becomes, can you pay that back? Do you have $2.5 million sitting in an account? How does it get handled? Well, we don't know yet. We don't know what the company's going to do. But the company very well, and they have the right, can say, hey, we've overpaid you. You can look at all your lease forms, look at your division orders, look what you sign. If they overpay you, they get rights to recoup or get that money back. If you want to be quiet and take the risk that you don't get caught getting more money than what you should, you can do that. I do not recommend that. But you can. But when you get caught, if you will, getting too much royalty, well, the company's going to come back and say, give me my money. And you better hope that you still have royalties left to be produced, and that's going to be used to pay back the money. But if you get caught, if you will, if the company catches their mistake further on in the process, there's going to be a lot more money you owe them, which means if you're counting on any regular royalty stream, you might have just lost your royalty stream for many, many, many years. Or, gosh forbid, worse, perhaps you waited so long, or they didn't catch it at the beginning, you never told them, and now you owe them money, and it doesn't look like there's enough royalties left to occur moving forward from your property to cover that money. Please be careful. If you think you're getting over on the gas company, please be careful. If it were me and I looked and I saw, hey, look, it seems pretty clear a company is making a mistake and overpaying me, I'm going to tell you, I would let the company know, because I don't want to get into that situation. Also, you want to talk about disaster. Say they catch it in 20, 30 years. Well, you're getting all that money. You're paying taxes on that money. Now a company says, hey, you owe us $1 million back. You owe us $2 million, $3 million, $500,000. Pick a number. Well, and you don't have that money, and there's not that much royalties left to be produced. You got a big problem. So please, guys, be careful. You're listening to All Things Marcellus. I'll be right back after this very important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Getting into it, we have a short segment here. Sorry, getting fired up here as my phone went flying. Okay, want to talk about circling back yet again. I want to get to my point earlier, talking about these buzzwords, indemnification. Here, check this clause out from a lease. This was a Western Pennsylvania lease, but hey, look, these things can come from anywhere. Has the indemnification language in there, and within this lease, it says, has all the indemnification language, and then here's the last sentence: notwithstanding the foregoing. Again, notwithstanding the foregoing. Most people I know don't really know what that means. That's some legalese stuff, meaning despite anything else that you just read here, ignore it. Here's what's going to matter. So we're giving you all this indemnification protection, this liability protection. Then you run into this phrase, notwithstanding the foregoing. red flag time. Start paying attention, because essentially this is going to cancel everything else or override everything else, notwithstanding the foregoing. Watch those words. So here it is. Notwithstanding the foregoing, the provisions set forth herein, indemnification language, shall expire 1 year following the termination of the lease. So we'll protect you. We'll cover you from liability like we talked about above, but only for a year after the lease expires. Well, what if a problem occurs a year and a day later? What if there's some sort of problem that didn't make itself known, an environmental issue or something like that? Maybe a reclamation issue. Maybe they didn't reclaim it properly. Somebody got hurt, a child, somebody comes onto the property, gets hurt, and you say, hey, company, somebody got hurt because of what you did. Or, hey, company, you created an environmental condition that didn't reveal itself until a year and a day after my lease terminated, or maybe 5 years after, 10 years after. But this says that despite all these liability promises that we just gave you, that these promises and this liability coverage and indemnification shall expire 1 year following the termination of this lease. So why? If the company is going to indemnify you, why should they not continue to indemnify you after the lease ends for their activities? I'm not talking about other things. We're talking about their activities. You rarely see this type of language. Shouldn't be there. And, this is a big lease form. Not sure why it's there. But then we read on. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're looking at an indemnification provision. We're going even a step further. Company says we will indemnify you. We will hold you harmless. We will defend you. We will pay judgments against you if somebody gets hurt and they sue us as a company and you as the landowner. And believe me, they will. You would be protected, is what they're saying, unless something happens a year after this lease terminates or longer. Even if it was as a result of our activity, we're capping or limiting the time frame that we're going to indemnify you, defend you, and cover you. So God forbid a child comes onto the previous well site that's been reclaimed and is no longer there a year or so later. It wasn't reclaimed property, something's sticking under the ground, some type of defect is out there, and the child gets hurt. Well, they're going to sue, and the family's going to sue not only the company, but you too. And so normally you say, hey, company, I have this indemnification language. You have to cover me. Company says, well, this child did this a year and a day after your lease terminated. We don't have to do anything. You're on your own. Well, defending a lawsuit, whether you did anything wrong or not, is an expensive proposition. Whether you did anything wrong or not is an expensive proposition. You need to have coverage beyond the lifetime of the lease. But that's not the end, guys. It's not the end. It goes on. So, notwithstanding the foregoing, so despite everything else, the provisions set forth herein on indemnification shall expire 1 year following the termination once this lease is over, or such time as the lessee, meaning the company that you signed the lease with, or such time as the lessee is no longer the operator under the terms and conditions of this lease, whichever shall occur first. So what does that mean? Well, I'm going to tell you, I read this to mean, and different people read things differently. Remember, there's 9 Supreme Court justices here in the United States, and they don't always agree. But I can tell you what, I do not like this language, because this says to me that the lessee, who's the company that you're signing this lease with, that once this company, this lessee, is no longer the operator, which tends to mean the company drilling the wells and operating under the lease. You can have other partners who are not the operator, but it says lessee. So until such time as the lessee is no longer the operator, then the indemnification goes away. Now, maybe the intent is that once this lease is assigned or transferred or sold to another company, they pick up this indemnification clause. However, that's not how I read this, and this needs to be corrected. I look at this and look, why is it drafted this way? At best, it's extremely confusing, and at worst, which is very possible and maybe even probable here, once the company transfers, assigns, or sells your lease to another company, it looks like you no longer have indemnification, or you have at least a dispute and you need to fix it, and you can fix it. You just need to know how, and don't let things like this happen, and that could be a major, major problem. Get help, get assistance, because if you get sued and you do not have liability protection from the gas company, it is going to be a very, very bad situation. And I'll tell you, these are the type of things that can be corrected typically pretty easily. But you have to know what to do. You have to know how to correct these things. And as a lay person, indemnification, hold harmless, some of the most important parts and aspects of the agreement. They are very complicated, and people are making mistakes, and there's many ways to write them. So you got to be careful. You got to be careful. All right, I want to leave it, and I want to say, hey, look, we had a seminar this past week, and I want to thank everybody that attended. We had over 100 people pre-register in Wellsboro and Tioga County. We had a great turnout. Great seminar, and I want to thank everybody. Great questions at the end. We had great feedback, and I love doing it. I really, really do. And it really is nice to get out there, talk to people, understand the issues, talk directly to the people about the issues that they're facing, and hearing other questions and concerns. And I want to thank everybody that attended. We had a great time. It was a great facility at the Dean Center in Wellsboro. Outstanding experience. So thank everybody. Thank you for listening. You've been listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always contact us, 570-307-0702, 570-307-0702. I have clients all across Pennsylvania, and I'm confident if you need assistance, we can help you. But even if you're not looking for representation, if you want to learn more, go to pagasleaseattorney.com, go to pipelineattorney.com. Today's show will be up and available Monday morning, and many other shows are there. Use the resources, become educated, and remember, I almost didn't do it today. Remember, the landman works for the company, not you, the landowner. Stop signing bad agreements. And have a great week, everyone.